Court case Strunk versus Strunk, 445 SW2D 145, September 26, 1969. The circumstances surrounding the case involve two parents and two sons. One of the sons, Tommy, is in need of a kidney transplant because he is suffering from a chronic disease known as chronic glomerulonephritis, a fatal kidney disease. The only applicable donor is Tommy's younger brother, Jerry, who is a patient at a state institution and currently holds an IQ of 35, which is equivalent to that of a 6-year-old. The question in case here is, does a court of equity have the power to permit a kidney to be removed from an incompetent ward of the state upon petition of his committee, who also happens to be his mother, for the purpose of being transplanted into the body of his older brother who is dying of the fatal kidney disease? The lower court, which happens to be the county court in this case, ruled in the family's favor for the kidney transplant, and the appellate court was against the decision of the family. So two laws that are in question here go with Ex Parte Whitebread 1816 and Prince versus Massachusetts. In a case involving human transportation, the court should determine that the ruling would violate Prince versus Massachusetts, which states, parents may be free to become martyrs themselves, but it does not follow that they are free, in identical circumstances, to make martyrs of their children before they have reached the age of full and legal discretion when they can make that choice for themselves. The ultimate final decision maker was no, and the reason behind this was, at least given in the case, was, I am unwilling to hold that the gates should be open to permit the removal of an organ from an incompetent for transplant, at least until such time as it is conclusively demonstrated that it will be of significant benefit to the incompetent. The evidence here does not rise to that pinnacle. To hold that committees, guardians, or courts have such awesome power even in the persuasive case before us, could we establish legal precedent, the dire result of which we cannot fathom? Regretfully, I must say no. Now, the rule of law behind this is that this case establishes the rule that parental authority is not disclosed and can be permissibly restricted if doing so is in the intent of a child's welfare. While children share many of the rights of adults, they face different potential harm from similar activities. The ultimate decision in the case was ruled against that of the families, and it was a no.